Hi, this is Josh Bertram. Welcome to Faithful Politics. We got our buddy Will Wright, our political host. Will, how are things going right now?
They're going well. Pollen season is in full effect, and I've been reading out of the good book of Claire 10:3:16. No pollen shall form against me, because it's really bad.
It is, so it's weird. And we have Professor Eric Berger. How do you say it? Is it Esquire? Do you go by Esquire?
No. I mean, I guess technically, but no, I don't go by. You just call me Eric, please.
Yeah, I would use that all the time. If I had Esquire, I would just make people call me Esquire. I feel like. But it's so good to have you back. Professor Berger has been on our show a few times, actually. He's on staff at the University of Nebraska College of Law, an expert in the Constitution, teaches constitutional law and all sorts of awesome stuff. And you can check him out if you go to law.unl.edu and look up Eric Berger and all his stuff. It's Berger, and really accomplished legal scholar, and now becoming more of a friend for us. This is like the third or fourth time, right, that we've been able to talk, and it's really cool to see it. It's cool to see you not in a suit. I'm used to seeing you in a suit.
Is that right? I don't even remember.
A suit or like some kind of just like, not that you don't look nice. I don't want to. But it's nice to see it. Yeah, I mean, a collar shirt or whatever. I normally wear whatever, just normal stuff. Actually, it's funny because Will, the old political host, we went on C-SPAN. Did we tell you that, Eric? We went on C-SPAN. Yeah,
oh, no, that's awesome.
we got featured on C-SPAN on one of their shows, highlighting podcasts. And we got on there as the strangest experience because we couldn't see each other and we couldn't see the interviewer. We could hear him, but we couldn't see him. We could just see ourselves. But it totally looks like in the interview that we're all talking and we're all there seeing each other. But that was not the case at all. And it was funny because I was wearing a suit and he didn't even know. Will didn't even know I was wearing a suit. And he was like, wearing some
hippie looking thing.
Yeah, some hippie looking T-shirt that said something offensive on it.
As the liberal, I was dressed like a liberal, and Josh was very much dressed like the Republican. That
was right there. Dude. I should have been
always good to live up to stereotypes, right?
Yeah, dress the part,
Exactly.
I've said before when I've been on your show that I think it's so important for liberals and conservatives to speak to each other. I think it's really distressing.
Yeah.
The state of our nation right now, I think, we're really so divided. So having a show where people can come together in good faith, people of faith and people who care about politics and who might disagree with each other about important things and, try to find common ground. And if not, to agree to, disagree respectfully and to realize that we all want what's good for this country. It's really important and never been more important, something like this. So I really applaud what you're doing, and I'm glad you're getting the recognition you deserve.
Yeah, well, thank you so much. That means a lot. But it's so great to have you on. We're looking forward to this conversation. We're actually going to be talking about abortion today, the legal aspects of it. Again, with looks like we're coming up on potentially Roe v. Wade being what do you call it? What is it? Is it? I almost said recanted, but that's
like overturned.
Overruled. There you go. There you go.
It will be, but that's before the Supreme Court this term, and in all likelihood, a decision will come by the end of June. So we'll find out.
So just to get us started, what if you could just just kind of describe for us as you see it and as you know it, Eric, the state and the atmosphere and context of abortion, the legal aspects of it, of abortion in America? Because people think all sorts of things about it. They think all sorts of, like, we have all sorts of ideas, and we think about Roe v. Wade, and a lot of people maybe don't even know that one of the major issues, right, was privacy in Roe v. Wade. I mean, it's like, what? Like, what does that have to do with babies? But, like, you know, so many people, like, have different views to this. So what kind of walk us through the legal, you know, legal process and legal history of abortion here as you see it and understand it in America? Like, that's brought us to where we are now.
So I guess it might be helpful to start in the 1960s. In the 1960s, most abortions were illegal in most states. So most states criminalized abortion, and there was no constitutional right to an abortion. Despite the fact that abortion was illegal in most states, abortion still happened, and they happened in two different ways. There were some cities and states that just didn't enforce their abortion laws. So in those places, a pregnant woman who wanted an abortion could go into a doctor's office or a hospital clinic and get an abortion, and it was technically against the law, but everyone knew in those places the law wasn't being enforced. And that's actually somewhat similar to roughly that same era. There were laws prohibiting contraception in some states, and it was sort of the same thing. It was on the books, but nobody enforced it, and a lot of people would have been, astonished to think that it would be enforced. In other parts of the country, though, the laws were enforced, so you couldn't get an abortion at a doctor's office or a hospital, and there were lots of women who got, what some people call back alley abortions, using primitive methods. Very, very obviously very dangerous procedures. They can be unsanitary, and that resulted in, women dying and many other women suffering serious medical harm. Because they were illegal, and we don't have accurate numbers about how many abortions there were, but there are some studies that estimate that in the 1960s there were roughly a million abortions per year. So abortion still was happening, but it wasn't legal, and as I said, a good number of women died or suffered serious medical harm as a result of that. Public opinion on abortion changed really radically and really quickly in the late 1960s and early 1970s. According to Gallup polling, in 1969, only about 40% of Americans supported abortion rights. By 1972, that had climbed to 64%. That's an astonishing change in just a few years.
Wow.
40% to 64% in just 3 years. Now, it's so astonishing that it makes me wonder a little bit how reliable are those polling numbers. But even if they're not entirely accurate, I think they are largely accurate in demonstrating a dramatic shift in Americans' attitudes towards abortion. One other thing I'll point out about the early pre-Roe politics of abortion is it did not break down along either the political or the religious lines we're used today. And I don't think that is of legal significance, but I think it is of historical significance. So in the early 1970s, around 1972, I think about 68% of Republicans agreed with the statement that the decision to have an abortion should be left to a woman and her physician, whereas a smaller number, 58% of Democrats did, according to this poll. So a majority of both Democrats and Republicans in 1972 favored a right to abortion, but a much higher percentage of Republicans did. And obviously, the politics of that have just shifted dramatically. You might ask, well, why was that? Why? So I think there are two explanations. The first is that the political parties were far less ideologically polarized and even less ideologically rigid than they are today. So, whereas today, Democrats march in lockstep on a bunch of social and political issues, and Republicans march in lockstep on a bunch of political and social issues. That just wasn't the case in the 1950s and 60s. So there were lots of liberal Republicans and lots of conservative Democrats. The other reason is Catholics voted, majority Catholics voted Democrat, and Catholics were overwhelmingly opposed to abortion. So that's another reason why Democrats opposed abortion more than Republicans did in the early 1970s. Incidentally, Protestants, including evangelical Protestants, tended to favor abortion rights at that point in the early 70s, including groups like Southern Baptist Ministry, which I think is sort of astonishing to us today, given how influential the evangelical movement, for the large part, has been in opposing abortion rights. Obviously, there's some evangelicals who favor abortion rights, but on the whole, I think in contemporary America, we tend to think of evangelical Protestants as strongly opposed to abortion. That also wasn't the case in the early 1970s. So, so you had changing poll numbers where abortion is becoming, or abortion rights are becoming far more popular in public opinion. But state laws don't always catch up immediately with public opinion. And even though in this era there were some states that did vote to liberalize their abortion laws, I think only 4 actually completely legalized abortion. And I believe, I don't have it in front of me, but if memory serves, I believe it was Alaska, Hawaii, New York, and Washington. And there were some other states that didn't entirely legalize abortion, but that relaxed restrictions on abortion. But there were other states that didn't. And I think one reason for this is it's just hard to achieve anything in the legislative process. I think anyone who's tried to get a bill through Congress or even state legislatures knows there are lots of veto gates along the way. And even measures that are popular sometimes get defeated along the way for various political reasons. And of course, the politics weren't the same in state to state, and in some of those states, the right to abortion was still unpopular. So this is also the era of the rise of women's rights. The Equal Rights Amendment was getting on the table, which would have given women equal rights under the Constitution. There was a burgeoning feminist movement, and there were lots of women who were just unwilling to wait for state laws to catch up with public opinion. So they started challenging abortion restrictions in court. And by the time you get to 1973, the U.S. Supreme Court has the famous case of Roe v. Wade before it. So in January of 1973, the Supreme Court, in an opinion by Harry Blackmun, ruled that a Texas law that criminalized abortion, I think in all instances except to save the woman's life, was unconstitutional. And Josh, as you said earlier, it rooted this ruling in the right to privacy. And there are things about that are kind of odd. So one thing that's kind of odd is when you think about what, whether or not one believes in the right to abortion, when you think about, well, what is it about a state saying you can't have an abortion? What kind of right does it really implicate? A lot of people would say, well, it might implicate women's ability to participate equally in society and the economy, or it might implicate things like decisional autonomy, a woman's ability to make important decisions about reproduction and about her body. Privacy, maybe is part of the equation, but it doesn't seem to be as core part of the equation. So it did seem like an odd place to root it.
Yeah, it seems really odd. I'm just interrupt you for a second because I think this is important as you're bringing us the context. Is awesome. It's so nice. It's so cool to just hear it in one place instead of going to all over, all these different sources to find it. But how is it that we can, because obviously abortion isn't in the Constitution, right? The word abortion is not in the Constitution. It's not there. It's not said. How is it that we can take, just because this has always kind of confused me, how can we find these rights? What's the process that they use to say, oh yeah, abortion isn't in there, but this protects abortion? How is it that we can get from A to B?
No,
or it seems like sometimes it's A to Z, and we don't even know what B through X is.
Well, it's a great question, and I'll try to give a concise answer. Though these are sort of questions that one can spend an entire law school semester trying to wrestle with. I think, I suppose as a preliminary matter, I think it's worth saying that legal scholars disagree with each other about how problematic this is, right? And I think there's some legal scholars who would say something along the lines of what you just said, Josh, which is it's not in the Constitution's text. Judges have an obligation when they're interpreting the Constitution to follow the Constitution's text. And if it's not in there, judges shouldn't read it into the Constitution, and that doing so risks importing their own values. I think there are a few counter-arguments to that. One counter-argument is if you pick up, a constitutional law casebook, and they're pretty thick. Actually, I don't know. I just picked it up and showed it to you guys. Are we? Can your viewers see us, or do they just hear us?
Yeah, they will be able to. Yeah, people who are hearing can't. Okay. But.
Yeah, so for those that are only listening, Eric just picked up a 2-ton book that had
he
lots
was struggling to pick that thing up, dude. It was like he was
I'm getting
out.
old, man. So if you study constitutional law, I think one of the things you'll learn pretty quickly is that not all, but many of the important doctrines we learn in law school are actually not rooted in the text of the Constitution. Some might have kind of loose connections to the text. Others don't appear in the text at all. Others are kind of creative extrapolations from text. Some seem to fly directly in the face of the text. So just as a historical matter, the argument that because a particular right, like say the right to abortion, isn't found in the Constitution, isn't really decisive as a constitutional matter, because if we really required strict adherence to text, the vast majority of U.S. constitutional law would have to be reconsidered. Not all of it, but a lot of it. A sort of second argument that is more precisely connected to individual rights is there is a textual, the Ninth Amendment's text in the Constitution explicitly says that the fact that other rights are enumerated in the text of the Constitution should not be construed to mean that other rights don't exist. In other words, when James Madison in particular and some of his contemporaries were contemplating the idea of a Bill of Rights, Madison initially was strongly opposed to a Bill of Rights. And that's sort of a whole difference. We could have a whole meeting about that. But one of the many reasons he was initially opposed to the Bill of Rights, he said, well, we won't be able to list everything that's important. It's inevitable we'll forget things that are important, or there's things that are just not on our radar screen that might be important. And there's going to be some clever lawyer out there in the future who, if we list rights A through Z, or 1 through 10, they're going to say, well, what about right 11? And that lawyer is going to say, well, you didn't include right 11, so the fact that you included 1 through 10 suggests that number 11 isn't included. And Madison was very concerned about that. So the Ninth Amendment explicitly addresses that issue and says, effectively, well, just because we didn't list it doesn't mean you don't have it. Now, I guess 2 caveats to make about the Ninth Amendment argument. One is, I think the Ninth Amendment argument is an effective rejoinder to the argument that says, well, if the right to abortion is not in the text, that means it doesn't exist. Because the Ninth Amendment, I think, makes really clear that the framers of the Bill of Rights wanted to foreclose that argument. They didn't want future generations to say, well, because this right isn't explicitly listed, you necessarily don't have it. However, that doesn't necessarily mean that any particular right exists. In other words, that doesn't mean there is a constitutional right to abortion. In my mind, it just means that the fact that the Constitution's text doesn't explicitly grant the right to abortion isn't necessarily decisive. So that's the first caveat about the Ninth Amendment. The second caveat about the Ninth Amendment is that the U.S. Supreme Court has paid almost no attention to it in 220 years. The most attention they paid to it was actually in a concurring opinion about the right to contraception that was decided in the 1960s, a case called Griswold, decided actually only not that many years before Roe v. Wade. But they haven't really cited it much at all, and they've barely relied on it at all. While I think I think the justices I think their doctrine reflects the Ninth Amendment principle insofar as lots of rights that they have recognized cannot be found explicitly in the Constitution. It's kind of odd that they haven't referenced the Ninth Amendment more in recognizing those rights. And I think one of the reasons might be, well, it's hard to come up with neutral principles under the Ninth Amendment to decide which rights count and which rights don't count. But in all events, it makes the area sort of doctrinally a mess. So I guess long story short, Josh, there are legal scholars who make the same argument you do. Right to abortion isn't in the Constitution, therefore it doesn't exist. But as I said, I think there are counter arguments to that textual argument. That doesn't necessarily mean that Roe v. Wade was rightly decided, but it is an argument that you can't rely entirely on the constitutional text to understand.
That makes a lot of sense. So when I'm thinking about this, one thing is that it reminds me a lot of the Bible. And interpreting the Bible. There are, one thing that's very interesting, abortion isn't mentioned in the Constitution. It's not mentioned in the Bible either. And it existed back then. There's no place that mentions abortion. There are some places that are, that explicitly outlaws abortion. There is no explicit outlaw of abortion in Scripture. We had a great Old Testament scholar, Tripper Longman, come on, and it's and he talked about that, and he went through kind of some of the arguments there. So the idea that you need to take a text and apply it when it isn't going to be explicitly there, that makes sense to me. It makes sense to me.
Yeah, and I'm wondering, is it wrong when anti-abortion activists use, the colloquial term, it's unconstitutional what you're doing, with the laws? Is that statement wrong? Or is it nuanced? or is it like, just taken out of context?
When abortion supporters say that, for instance, that state laws that are currently being passed interfere with the right to abortion?
Oh, no. Like when people that are pro-choice say, the laws that you're doing, in
Right.
Texas, Oklahoma, what have you, like it's unconstitutional, that you're passing
Right.
these laws. Like, is that a correct way
I think that is
to phrase it?
under current Supreme Court doctrine, I think that is a correct statement. In other words, right now, April 15th, 2022, Roe v. Wade is still the law of the land. It has not yet been overruled. So there is a constitutional right to abortion. And therefore, these laws that, that are prohibiting abortions are unconstitutional under current doctrine. However, as everyone knows, the U.S. Supreme Court is currently considering the Dobbs case out of Mississippi, and there's a pretty good chance that it will, at the very least, cut back on Roe v. Wade and quite possibly overrule it altogether, in which case those state laws prohibiting abortion that are unconstitutional today in April 2022 will be constitutional, in July 2022. We'll obviously have to wait to see what the Supreme Court says. But as a matter of current law, it is not correct. It is correct to say those laws are unconstitutional.
Got it. So in the Dobbs v. Jackson case, and like you said, that's currently, I guess we're waiting for the opinion. I think the arguments are over, if I recall. And I think they're planning on giving their opinions in June or July sometime. I'm curious, so how will that case affect Roe v. Wade? So for us law people, we hear that, okay, if they rule, I don't know if it's in favor or against, but if they rule in such a way that it makes abortion illegal or makes abortion or limits people's ability to get an abortion in Mississippi, how does that affect Roe v. Wade, or how does that overrule Roe v. Wade?
What Roe essentially said is that Roe set up a trimester framework, and then a subsequent case called Casey from the early 1990s kind of tweaked Roe. But Roe did not say there was an absolute right to abortion. But Roe basically said in the first trimester, states cannot prohibit women from getting an abortion. In the second trimester, states can pass laws that regulate abortion to protect the women's health. And in the third trimester, states can prohibit abortions altogether if they want to. As I said, Casey tweaked it a little, changed the doctrine a little bit, but it upheld the basic right to an abortion. But under both Roe and Casey, abortion isn't a sort of absolute right. In other words, states can't prohibit abortions before a certain time, but they can prohibit it after a certain time. After Casey, the line is viability, which is when a fetus can survive outside the womb, which I think is roughly 23 or 24 weeks or something like that. So one important point to make about both Roe and Casey and the current law in April 2022 is the Supreme Court is saying that states cannot prohibit abortions before a certain date, or before a certain point in the pregnancy. Again, now under Casey, it's viability. So, if the Supreme Court in Dobbs were to overrule Roe, that would mean that Roe is no longer good law. And that would mean that there is no constitutional right to an abortion anymore. And that would effectively turn the question back to the state legislatures, which in effect would mean that certain states, mostly red, Republican states, heavily Republican states, red, what we call red states, either have already or would pass laws that either sharply limit or entirely remove a woman's right to an abortion. But blue states, Democratic states, would not. So blue states would still offer a right to offer abortions, and abortions would be legal in those states. But red states would not, and then there would probably be some, purple swing states that would, could kind of go either way. So again, if Dobbs were to overrule Roe, that would not mean abortions are prohibited across the country. It would mean that it's up to state legislatures. Now, there are some conservatives who want to see the Supreme Court take the additional step and say that abortion is flatly prohibited.
Sure.
That would be an extraordinary change. And I think, at oral argument in the Dobbs case, Justice Kavanaugh, one of the conservatives, seemed unsympathetic to that position. And my guess is Chief Justice Roberts would also be unsympathetic to that position. So I would be very surprised if there were 5 votes for that, because that would be taking the matter entirely out of the hands of the states. But what is, what is far more possible, and I think a lot of observers think likely, is the court in Dobbs will say Roe's overruled, and as a result, states like Oklahoma are going to prohibit abortions altogether, and states like Massachusetts will still have them. Does that make sense?
So, yeah, that makes a lot of sense. And the Washington Post has a great. We found a couple of them. Well, I have like the Guttmacher Institute. I'm sure I'm butchering the name. And then the Washington Post, they both have. I'm sure there are other sites, but they have like lists of all the different laws, like in all the states about abortion, like which ones would be trigger laws, which states have trigger laws. I guess is that what they're called when they come, like basically if it's overruled, it automatically takes effect. So I guess so let's just imagine that the Supreme Court comes and says Roe is overruled. How is it that they could then go further and say, and it's illegal everywhere? Congress isn't writing a law. Like, that's not Congress writing a law that it's illegal. So that opinion becomes law? I guess what I'm trying to, how does that actually work? Where is that opinion now that is basically considered law just the same way a law that's gone through the legislative process is a law?
So it's a really...
Does that question make sense?
It does make sense. I mean, I guess the first thing, to reiterate something I said earlier, is that would really be an extraordinary holding. And I think most observers do not think the court will do that. I would be actually pretty astounded if the court did that in Dobbs. Now, whether some of the really conservative justices, like Justice Thomas, Justice Alito, and Justice Gorsuch, might see Dobbs as a stepping stone to eventually getting to that more extreme holding down the line, I don't know. Some commentators have suggested that that might be their end game. If they did that, it would the reasoning would be something like unborn fetuses are the same thing as born people. Therefore, they are lives that are protected by the 14th Amendment. The Due Process Clause of the 14th Amendment prohibits states from taking life, liberty, or property without due process of law. So the reasoning would be something like laws that permit abortion violate, take those lives without due process and therefore are unconstitutional. So it would be a constitutional ruling, ironically, kind of similar to Roe v. Wade itself, in that it's rooted in presumably the due process clause of the 14th Amendment that then, would apply throughout the country because the Constitution is the supreme law of the land. Again, I don't think the Supreme Court is going to do that this summer. The problem with making predictions is you can easily be proven wrong, and I've predicted things in the past and have been very wrong. But the parties were not arguing that in this case. And as I said, I think as I think and as probably most of your listeners know, if you look at the ideological breakdown of the court right now, there's 6 Republican appointed justices, 3 Democratic appointed justices, and unlike in some past generations where the party of appointment is not necessarily a good proxy for a justice's ideology, nowadays it is. So basically we have 6 conservatives and 3 liberals, but you still need 5 to get to a majority, and I would be astonished if out of those 6 justices you would get 5 votes for that. You might get a few, but I would be surprised if you get 5. Certainly not now. Now again, there are changes in the law that have happened that 10 years ago, I think a lot of us would have found astonishing. So, it could be kind of incremental. So if we meet again in a couple of years, it could be that something I'm saying that sounds off the wall now could actually be on the wall in a few years. But
totally.
But that's sort of how it would work.
Now, I have a question. So the last our last interview was with a anti-abortion activist, author, Abby Johnson. So they made a whole movie called Unplanned about her experience. She was a director at Planned Parenthood, and she basically quit after 8 years having witnessed an abortion herself. And in our conversation, she had mentioned, that life begins at conception, and that she doesn't even take birth control. And I'm wondering if there is, if there's this threat, this fear, or possibility that should Roe v. Wade get overturned, that maybe at the state level, that they even, they redefine what abortion really means, and it's, somehow it's at conception, and then they outlaw birth control. Is that something that's even possible, or am I just?
Do you mean the morning after pill? Is that what you mean? Once it, before it's implanted on the wall?
No, even just the
birth control,
the monthly pills that you take.
Gotcha. The birth control pills.
Mm-hmm.
That would, gotcha.
I think. Well, I mean, I guess I'll say a few things. One point I'll make. John Hart Ely, who was a prominent constitutional scholar in the second half of the 20th century, he once said something along the lines that, abortion's really difficult because on the one hand, it seems too much. On the one hand, it seems like infanticide. On the other hand, it seems like contraception. And, which it is going to determine our views on it. I mean, I think almost everybody thinks that killing babies is terribly, terribly wrong and has to be illegal. Today in 2022, certainly a significant majority of Americans, I think, favor the right to contraception. Now, there are, as you point out, Will, there are some different contraceptions work different ways, and those that might take effect after sperm has fertilized the egg, depending on one's conception of these things, I suppose could be thought of as abortion. We're not at that point yet, but it's certainly possible that the Supreme Court could write an opinion in such a way that would inspire anti-abortion groups to take further steps to criminalize or to make illegal certain kinds of contraceptive methods, and then that might get tested in the courts again. I think one of the things I tell my class when we do abortion is one of the things that's so hard about it and so hard talking about it as a legal matter is I don't really think there are neutral judicial principles that can sort of definitively decide the issue for us. And I think to some extent it just depends on how does one see a fetus, a pre-viability fetus. And if you think a fetus is the moral equivalent of a born human, then abortion is murder. And even if you think the woman has an important right to control her own body, presumably the right to protect against murder would trump that woman's interest in her liberty, in which case banning abortion makes perfect sense. By contrast, if you think a fetus is not the equivalent of a born human being, then abortion seems a lot more like contraception, and then the woman's interest in equality and ability to make important decisions about her body and about reproduction would seem to trump the state's interest in prohibiting, what is effectively a kind of contraception. And what's difficult is there's no scientific answer to the question of what a fetus is. I think that's a question each of us, each person sort of has to decide for themselves. And that, of course, includes the Supreme Court justices. So each of them has their own personal view of that question. And their personal view of that question is necessarily going to drive their legal analysis. But no matter how impartial they're trying to be, I don't think one can answer that question of whether a fetus is a person solely by reference to the law. You can look, perhaps to things like, well, how do we think about fetuses in our culture more generally? I don't know that those are definitive though.
Yeah, I actually, so if there's a decision, and I hate to kind of throw out these hypotheticals at you, but these are just the things that I'm thinking about and things that I know our listeners and whatnot have asked, is that if a decision is made that a fetus is a person, wouldn't it reason that a place, that favors abortion, or a person that favors abortion would ask that person have all the same inalienable rights as, I don't know, like you or I, or have the benefit of. So if my wife is pregnant, before the baby is out of her, and before we give birth, I should probably say, that's probably a better way to put it, then would we be able to claim that baby on our taxes, or add them on our life insurance, or, like just the normal things that people do when they have kids? So like, question. Would that be something that somebody can make a strong argument for, if they determine that a fetus is a person?
I suppose if the court were to explicitly say a fetus is the exact same thing as a person, that's sort of like parade of future questions would be before us. I think what is more likely is that the court won't explicitly say that, but if the court overrules Roe, it would say something like the right to an abortion is not a right that is properly found in the liberty component of the Due Process Clause of the 14th Amendment. And it wouldn't take a stance on whether a fetus is a person or not. Rather, it would say that there's no constitutional support for the idea that a person has a constitutional right to an abortion. And again, that would leave the matter to the states. I think that's the more likely way the court would resolve the question.
Yeah, that makes sense. I mean, that, when you were talking about that, well, what it made me think of, and what I was even thinking of several times throughout this, is this idea with the trickiness of abortion, right? Are you serious, dude?
Oh, no, you have fire?
I have
a
a fire alarm.
Oh, hey, that's fine.
Well, let me ask this question and you can answer it, and then. But I know I apologize for that in the background. But so it's at the center. Yeah, at the center of this idea is that you have a legal definition of a person, a moral definition of a person, a scientific definition of a person. Like, you have all these different things, right, that come together, and the way people form their opinions on who's a person and who isn't. And it's like, I guess my question is, legally, how do we we define a person legally? Is that personhood defined legally? And at what point do we define it legally? And what legal principles do we use to even define what a person is?
I mean, it's a great question. I don't have a great answer. I think you filibustered the fire alarm. I think.
I think he just muted himself.
Well, I mean, don't catch on fire, Josh. And, I think the, one way of thinking of it is those are all difficult questions. And really, in a sense, the constitutional question is who should decide that? And what a lot of the opponents of Roe v. Wade have argued is that issue should be left to the state legislatures. In other words, rather than having federal judges, effectively the 9 justices on the U.S. Supreme Court or some slim majority of those 9 decide that question is wrong in a democracy, that in a democracy we leave those decisions ultimately up to the people. And by leaving it to the people, we leave it to each state's legislatures to decide how to treat abortion. And effectively, those state legislatures are making that determination. Now, I don't know that any of them are making it with great philosophical depth or precision, but they're essentially trying to reflect the values of their constituents and saying, this is how we're going to treat it. So I think that's one way of looking at it. This is effectively a really difficult moral decision, and we shouldn't have federal judges dictate to the rest of the country what their morals should be. We should leave that up to each of the 50 states. Obviously the counter argument is that if there is not a right to abortion, that impinges a great deal on many women's liberty, and that there are women who get pregnant who did not intend the pregnancy, many of whom actually were on contraception and it failed, and carrying a baby to term for 9 months is an infringement on liberty, and having to care for a child, is obviously a life-altering event, and that, so the counter argument would be that no government should tell an individual that they have to do that. No government should tell a woman that she has to have a pregnancy she doesn't want and has to have a baby that she doesn't want. So those are some of the competing ways of looking at it.
Yeah. I think Josh just messaged me that he may return, but depending on the current. Yeah, I'm sure he is. That is kind of annoying, but I mean, they make fire alarms for a reason, right? So, but I'm curious there. So with all these states coming in with their anti-abortion laws, and I think Oklahoma has probably one of the most stricter ones. I think they signed it. I can't remember if that's the state they signed it and it got vetoed, or maybe I'm thinking Kentucky, but how are they able? I mean, so you get a bunch of state legislators, they say we're going to do this thing. The thing that they do is completely in on its face, in opposition to what the laws say. Like, how are they able to do that? I mean, I know states have a lot of power, but it's like if Virginia all of a sudden voted that they wanted to make slavery, like legal again, like I'd like to think they wouldn't be able to, even if they had voted for it.
They certainly wouldn't be able to, because the 13th Amendment very explicitly prohibits slavery. And I think reasonable people can disagree about whether the Constitution protects a right to abortion, and there are plausible arguments on both sides of that issue. There are not plausible arguments on both sides of the slavery issue. The 13th Amendment, in no uncertain terms, prohibits it. And that obviously was ratified in 1865 at the end of the Civil War, and resolved once and for all the biggest moral issue this country had to face in its the first 80 some years of the Constitution. So state legislatures' powers are not unlimited, and they're limited by the Constitution. The question, of course, is what does the Constitution permit and what doesn't it permit? The Supremacy Clause of the Constitution also makes clear that federal law trumps conflicting otherwise valid state law. So federal statutes also can trump state legislatures where the federal law is valid. So again, state legislative power is not unlimited. On the other hand, our system historically and constitutionally has let states decide a lot of important issues that go within their borders. Questions of health, safety, public welfare, morals are typically left to state legislatures. But then, of course, there are questions about when does a state legislature go too far? Your slavery example is a case where clearly goes too far. I think the vast majority of Americans would agree with that, and all 9 justices in the U.S. Supreme Court would agree with that. That's an easy case. Abortion's a hard case, and as I've sort of tried to lay out earlier in the conversation, there are non-frivolous arguments on both sides of that issue. One argument that I haven't just flagged yet, but I think is important for your listeners to know about, is precedent and what role precedent plays. Obviously, the supporters of the right to abortion, one of the arguments they make is Roe v. Wade has been the law of the land for 49 years. And the Supreme Court should respect its own precedent. And the Supreme Court has never before overturned a precedent that granted a right. It's overturned precedents that took rights away, but it hasn't overturned a precedent in this kind of way. So when you think about a case like Brown v. Board of Education, which overturned Plessy v. Ferguson, Brown I think probably thought of granted rights. Were the Dobbs case to overturn Roe, it would take away rights. So then the question is, well, how much respect does the U.S. Supreme Court give precedent? At oral argument in the Dobbs case, Justice Alito signaled pretty clearly that he thought it was proper to overturn precedent that is, clearly wrong. And it's pretty clear that he thinks Roe v. Wade is clearly wrong. My guess is Justice Gorsuch and Justice Thomas also think it's clearly wrong. So the question is, are there 2 other votes to do that? I think the other 3 Republican appointees on the court, Chief Justice Roberts and Justices Kavanaugh and Barrett, my guess is all 3 of them think Roe was wrong. All 3 of them don't like abortion. I would guess that the Chief Justice is, he's very concerned about the institutional legitimacy of the Supreme Court and the reputation of the Supreme Court. And my guess would be that he would maybe allow the Mississippi law, which was, I think, a 15-week cutoff to stand, but wouldn't go so far as to overrule Roe entirely because he worries, again, that that would just look like too partisan. So then it really turns on Barrett and Kavanaugh, whether they can be the fourth and fifth vote to overturn Roe. I've read a lot of commentators who think they will be. We'll probably know within 2 to 3 months.
Wow. Yeah, that's really crazy. And I so like in a situation like this, would Roberts be the one that writes the opinion? Because it is such a huge, like everyone seems to be looking at this case as like, okay, what's going to happen? And if it does overturn it, then like that's going to be in the history books for sure.
So the senior most justice in the majority on a Supreme Court case gets to decide who writes the opinion. So if the Chief Justice is in the majority, he could either assign it to himself, and very well could, or he could assign it to any of the other justices in the majority. There is a possibility that the Chief Justice would not be in the majority, that the Chief Justice, that there would be 5 votes to overrule Roe, and the Chief is not willing to go there. In which case the senior most justice in the majority would be Justice Thomas, and he would get to assign who writes it, and he could either assign it to himself or assign it to Justice Alito or whoever he chose to assign it to.
Yeah. We know he's not going to assign it to anybody. He would take that up himself, I'm sure.
I don't know. It'll be interesting.
Yeah. No. So I guess if you were a betting man, like what's your sense, like probability wise? You think there's greater than a 50% chance it'll get overturned or less?
Don't put me on the spot, man. I think there's a much better than 50% chance that the Mississippi law will be upheld. That was the 15-week ban. So I would say, 80% chance that Roe is cut back. And Casey is cut back. Casey again set the line at viability. States couldn't prohibit abortions before viability. That's 23-ish weeks. I might have the number slightly off, but low 20s. Mississippi set it at 15. I think there's a pretty good chance that the court will uphold Mississippi's law and therefore at least cut back on the right in Casey by saying states can prohibit abortions earlier than they could under the Casey regime. I think that's pretty high. I'd say 80%, maybe even higher. Whether the court goes so far as to overrule Roe entirely and say there's no right to abortion at all, states can prohibit abortions whenever they want, at whatever point in pregnancy they want, that's closer. I think that's more like 50-50. Maybe if I hate to be put on the spot because I'm always, whenever I guess these things, I'm always wrong. But I would say slightly better than even that the court overrules Roe. But I'm not sure. Another thing we haven't talked about is the political implications of this. And, there is an argument that Roe v. Wade is one of the best things that ever happened to the Republican Party. Because even though the backlash against Roe didn't happen immediately, by the time you got to the late 1970s, you had conservative leaders sort of galvanizing evangelical communities and actually turning the evangelicals from largely pro-choice to very staunchly pro-life. Ronald Reagan did a great job of using that, sort of like tapping into that sentiment and running on that. And really, ever since Reagan, the Republican Party has been a very strongly pro-life party, and And I think that issue has really helped mobilize the Republican base. So now, were the court to overrule Roe, it's hard to know exactly what the political fallout would be. I've read some commentators who say, well, maybe overruling Roe would galvanize Democrats the same way that Roe, again, not immediately, but eventually galvanized Republicans, and that maybe Republicans would be less fervent or less reliable voters since they would have accomplished their great aim. On the other hand, as I said before, in all likelihood, if Roe's overruled, it's going to turn the issue back to the states. And then there's still battles in all the state legislatures about whether to make abortion illegal in each of the 50 states. So elections still would have a great impact on those issues. And I just mention that because I think the justices are aware of those political implications. And, exactly how that will figure in their decision-making, I don't know. You can be pretty sure that they won't be candid in their opinions about how it does figure. But I think at least in some of them, that's going to be in the back of their mind. And I just don't know how, Justice Kavanaugh in particular would weigh those things.
Yeah, that's so true. And I've thought about that too, that if it were to be limited or overruled, if it would activate Democrats, especially going into a midterm election. So, I mean, here in 7 months, we're going to be seeing Congress probably change hands, and the House definitely, the Senate yet to be determined. But if an issue like this would activate people, I mean, as a Democrat, I would hope it would. But I've said it for a long time that Democrats are really good at snatching defeat out of the jaws of victory. So who knows? Who knows?
Yeah, I think that.
But hey,
right.
But Eric, go ahead.
That the Democratic Party has a tremendous capacity of snatching defeat from the jaws of victory.
Yeah. So Eric, thanks again so much for lending us your expertise. We really appreciate having you.
For hosting me again. Yeah, it's always great to talk to both of you. I hope please send my best to Josh. I hope you're okay and that it's just really a drill.
For sure. I will pass it along. Hopefully not posthumously. So and. If you, I just lost my train of thought. Anyways, thanks everybody for listening, for watching, and we will see you all next week. All right, goodbye.